aside the processes and proceedings which led to
you complete the reading of SBD if you want to.
No, my lady, you said the point was made and I was bearing to it.
Very well.
Yes, so I'll do it. So, the basis of paragraph 49 yes, my paragraph 49 arises from the observations made by the court before its ruling on the basis of which it made the orders. And
your paragraph 49 is premised on observations by the court
made in the course of its ruling
in the ruling of
18th October, which is sought to be set aside in this application. In the fourth page of the ruling of the court, starting from the third paragraph.
Attached us.
Yes.
Attached us.
Exhibit B. There is a finding by the court that the applicant, or the court observes that the applicant urges, and we appreciate that the said ruling would also likely lead to alleged thwarting of government business in Parliament and plunge the due management of the affairs of the country into possible disruptions. And so the court then, on the basis of that, makes its ruling in Exhibit A and notes that.
No, hold on.
Point also, yes.
Hold on. Yes. So the partisan political aspersions arise from the observation of the court on the submission of the applicant in that time.
Yes, my lord.
At that time.
Yes, my lord. Because in the ruling of the court, if my lady looks at the second page of the ruling of the court, I think if we start from, the court makes the same observation. Exhibit A.
Exhibit A is not the ruling of the court.
No, my lord, those portions of the submissions that were made to the court were relevant and that informed the ruling. That's what I'm saying.
Yes. Exhibit A.
Yes. No, those were the proceedings.
Yes.
Mr. Sorry.
So it is not. Your exhibit A is not the ruling of the court. So just refer us to the proper exhibit. Which contains the ruling of the court.
So I started from the proceedings and I'm now ending with the order. The order also the order just makes the same finding. If my lord should take a look at the paragraph that says the applicant urges the court.
Where are you reading from?
After listing the parliamentarians affected by the ruling, there's the next paragraph which starts with the said four constituencies, and then it goes on to say the applicant urges, and we appreciate that the ruling.
So you are reading from Exhibit B.
No, just check A. Check A. The order that was sent. Yes. Yes. The cover letter is marked A, but attached to it is then the order of the court.
Mm-hmm.
And so that was taken into account before the court then makes the extensive orders relating to even 4 parliamentarians when the writ itself affected 3 parliamentarians. It didn't even include Article 97, 1 each. And so all of those orders were made based on some of those findings. And I'm saying that, and the position is that the first defendant, based on these things, expects that in order not, especially when the court reaches the conclusion that on the balance, there was no balance, there was just one side of it, because it was an ex-parte application, and they were heard. What was the balancing?
Sorry.
Yes.
I thought you were just responding to a very straightforward.
Oh yes.
Thing. But now it appears that you are veering into the substance of the motion itself.
No.
I would urge you, rather, to restrict yourself to the objection that he raised and answer it, whether it is scandalous or it's not scandalous.
It is not scandalous.
My problem is,
yes, madam.
If your learned friend on the other side has raised these matters and you think it's not scandalous, you don't have to, as it were now, veer into the substance of the application itself.
My Lord, I needed to demonstrate that these things were not just said out of any...
No, just restrict yourself to...
My Lord, that's again, I thought I was doing that.
Yes.
And so, as far as I'm concerned, apart from the use of the word scandalous, which he just used, he doesn't demonstrate how scandalous it is based on the context of the application that I have before the court.
You allege that the Chief Justice is privy to a breach of a constitutional provision. What are you trying to convey?
It may have been by reason of inadvertence. But if that is a statement of fact,
was it necessary for you to add that in your depositions? For you, what exactly were you trying to achieve by adding the point that the Chief Justice was privy to a constitutional breach? I think that is the point it was.
Oh yes, but the point is that if she was privy to it, her ruling must reflect that. If it doesn't, it's one of the grounds upon which I'm urging the court to set it aside.
But Mr. Sorry, the ruling, if you don't mind, let me draw your attention to the fact that the ruling says that if you look at the first page of Exhibit A, we note from Exhibit B the official report on the parliamentary debates on Thursday, 17th October 2024, pages 15, 16, and 17, that the Speaker of Parliament was aware that bailiffs of the Supreme Court had served the current action on him through the legal office of Parliament. His objection to this proper service of a process from the Supreme Court was that it had not been done on a Monday.
Yes, my lady.
That's what the ruling says. So hold on, please. So the ruling was quite clear. The source of the notification.
Yes, my lady. But that's even the source.
If I could learn.
Sorry, I thought my lady had finished. I'm very sorry. I thought my lady had finished. I'm honestly sorry.
Yeah.
Should I?
So the ruling was quite clear about the source of the observation that the Speaker of Parliament had been properly served. And the ruling appreciated the circular, administrative circular from the Chief Justice. The first Chief Justice was Chief Justice Edini Eboa in 2021, and myself issued another circular which clarified how all of Parliament was to be served. That is what you are referring to. Is that not so?
Yes, my lady.
And how does that veer into a partisan political agenda, including constitutional breaches?
The two are independent. Let me deal with the first one. My lady says the finding even by the court that it was proper service is the point we are making. That by reference even to the parliamentary proceedings that took place that day, it was clear. It is not, first of all, it's not the official report because it was just a draft one. Parliament had not yet gone through it and adopted it as an official one.
1 minute.
But the second thing is that the court could not have found without referring to the judicial circular in which the proceedings had indicated clearly that the first defendant was objecting that it was not in accordance with that. And the plaintiff appreciated it. So that is it. And this other, with regard to the partisan aspect of it, that one is distinct. It's a distinct point, and that one is based on the submissions made to the court that, based on the assumption that if one party is the majority, it is deemed that government business will be thwarted. That's based on that assumption. Because if the Speaker's ruling stayed, then there was nothing to show that whichever party was the majority or otherwise, government business will be thwarted. And the Constitution doesn't assume that the government in power would necessarily have majority in Parliament. So those were the issues that were raised clearly on the face of the documentation.
Mr. Sorry, are you still addressing the preliminary legal objection raised by the attorney
yes,
general, or we are dealing with a substantive matter, i.e. your motion to set aside the protest?
Oh no, I'm dealing with that matter, but I'm also responding to questions from the bench, showing why, if my lady says that it was based on the proceedings in Parliament, I'm answering that.
Kindly round up.
Yes, so my lady, there's nothing scandalous about it. They are based on matters of fact that arose out of the proceedings before the court, on the basis of which the court made the orders sought to be set aside. Yes, ma'am. Yes, ma'am.
Accuse that member of being, when the decision that is taken here is a collective decision by you isolate one member in your decision and accuse that member of being privy to a constitutional breach. You think that it's a proper thing for us to make this response?
Well, first of all, it's not a proper inference from the affidavit, because the person whose judicial the judicial circular does not make reference to the full membership of the panel. Oh yes, yes, because she was named in the circular. The rest of the panel was not named there. Yes, but I'm giving the background to that application.
I think it is not permissible.
Well, I'm not accusing, and to turn it into an accusation, it's not a fair inference to be drawn from the affidavit. Maybe my lord is borrowing his words, and then I have to answer.
I'm sorry, are you able to allow the court to tell you something?
Oh.
It's the proper practice at the bar is when the judge starts speaking, you stop. Do you not appreciate that?
Oh, my lady, I don't think my lord thought I interrupted him. I was just responding.
I beg your pardon.
Then you shall. It's a prosper. I don't think. My lord, I don't think.
Are you able to let my lord land before you start speaking? So we can have an orderly conduct for today's event.
So that's my worry I'm discussing. I'm not a policy. I don't think it's proper to isolate one man. Whether she knew or she don't know. I say, how for it? It is actually accusations across the board. You should know better.
My lord.
The friend has raised an objection. I would have thought that the gentleman did things you have done to see. Because what you have done is to isolate these people members of the panel and accuse them of constitutional breaches. And you know how serious that is.
My lord, can I answer? Very well. So, but I'm saying that it's not a fair inference from the affidavit, and with all due respect, we refer to a circular that had nothing to do with the panel, and so it wouldn't have been right. I would have been misrepresenting the circular if I put it in those terms.
Yes, Mr. Abedu, can we hear you on this preliminary point? He's done. He's done.
No, but is he done?
But yes, he's done.
I totally associate the
concerns raised by the Attorney General, and I have nothing more useful to add.
second. Sorry.
Now, Mr. Sorry, can we hear you on your objection?
Of the president arises from some of
so that my lord on the stream what?
Right to my lady the Chief Justice, to him being impaneled in this matter arises from the fact that at a point in time he was known to be associated with the New Patriotic Party. And in fact, he was a parliamentary candidate in one of their constituencies in the Volta region.
I think you said enough.
Very well. And
yes.
I just want to demonstrate from, especially again.
No, I think you said enough.
From the
I think you
proceedings
said,
and the
no, I think you said enough. Kindly resume your seat.
Very well, my lady.
Let's go.
Don't call.
This is like just case communication between she gives.
Registrar.
My lords, with respect.
You gave your privilege of please stand. You gave your privilege of addressing the court to your junior, so we will not hear you, not on these matters.
My lord,
we will not hear you.
I apologize. I was sitting in Parliament. When the speaker is talking, you sit. You don't stand. So when I make this mistake, accept it. And my junior,
please, Mr. Gatti, we will not listen to you at this point.
Okay. When you're ready, when now you decide that you are.
Mr. Gatti, we will not listen to you.
I'm just saying that, my lord. If
the court will rise now to give a.
Then you.
All rise.
Real time.